वाली स्लाइड अच्छी थी, वाली जो थी, ये जो लगी हुई थी वो अच्छी थी, पहले जो था आपके पास, बस कर। बिस्मिल्लाहिर रहमानिर रहीम, अल्हम्दुलिल्लाहि रब्बिल आलमीन, वस्सलातु वस्सलामु अला सय्यिदिल मुरसलीन, Sayyidina Muhammad wa ala alihi wa sahbihi ajma'een. Ma ba'd, my dear respected elders, dear brothers and sisters, assalamu alaikum wa rahmatullahi wa barakatuh. Welcome and jazakallah khair. Thank you for joining us this evening. This is Friday night, but mashallah, I'm impressed. Of course, there's Salatul Jum'ah on Friday already, but mashallah, you take the time to come on Friday evenings for these programs. So that, indicates to us that, mashallah, you are interested in these topics and, you have a desire to learn, and this is a good thing. So, jazakumullahu khaira. Because, sometimes in masajid, we find in the community, if there is a program or something happens and then no one shows up, then it's very demoralizing. So, jazakumullahu khaira. And this is online as well. We get multiple requests now every time we do something, if it's going to be, live streamed. So, alhamdulillah, we are putting it online as well. So, my brothers and sisters, there is no doubt, we all know, that there's nothing that's guaranteed in this world except for one thing, and that is كُلُّ نَفْسٍ ذَائِقَةُ الْمَوْتِ, right? That every single soul must taste death, right? This is what Allah subhanahu wa ta'ala told us multiple times in the Quran. So this is a reality, for every single one of us. And the question is, how do we deal with this reality? Now, of course, there's multiple aspects to this reality. The one aspect that, inshallah, we're going to be talking about tonight is what happens after we're gone, right? So what happens to us, what happens to, our body, what happens to our family, what happens to our wealth. And, one of the other realities associated with this reality is that nothing that we own in this world is actually ours. Nothing that we own in this world, or that we think that we own, is actually ours, right? Even this body, which you have come to know as Sikander, right? Me, this is not mine, right? Because it will be left here, and my ruh is going to move on, right, into the next phase. So there's nothing that we actually own. Now, for all of these things that we think that we own, what is supposed to happen and how is it supposed to be dealt with? So this is the topic, inshallah, for tonight's presentation. I'm going to go over some of the basic Islamic teachings and Islamic guidelines with regards to this topic, and inshallah, Brother Umar is going to go over the legal aspect of it. First of all, the Prophet sallallahu alaihi wasallam has told us, and this is related by Abdullah ibn Umar radiyallahu anhuma. This is a sound hadith in Sahih al-Bukhari. The Prophet sallallahu alaihi wasallam said that ما حق امرئ مسلم له شيء يوصي فيه يبيت ليلتين إلا ووصيته مكتوبة عنده. The Prophet sallallahu alaihi wasallam said that it is not permissible for any Muslim who has something concerning which a will should be made to stay for 2 nights without having his last will written and kept ready with him. Once again, it is not permissible for any Muslim who has something concerning which a will should be made to stay for 2 nights without having his last will written and kept ready with him. Meaning, right, to put it in simpler terms, that if any Muslim has any matter, any wealth, any debts, any obligations, right, and especially we're talking about obligations towards others, it is not permissible for that Muslim to stay longer than 2 nights without having it written down and kept with him. Right? Why? Because it has to do with huquq al-ibad. It has to do with the rights of people. And if I were to die and nobody knew, what I owe or how much, what I owe to whom and how much, then this would infringe upon the rights of the individuals who have trusted me with their wealth, or who have, lent me something, or who have allowed me to borrow, or who have, some sort of financial relationship with me. So therefore, it is incumbent upon us that we write down whatever it is that we owe to others. And this is something that Rasulullah sallallahu alaihi wasallam has made obligatory upon us. So this is the first point. Now, secondly, on that point, by the way, the narrator of the hadith, Abdullah ibn Umar radiallahu anhuma, he stated that after hearing this from Rasulullah sallallahu alaihi wasallam, he said, I did not let even one night pass except that my will should be kept with me. Right? This is how seriously he took it, to have it written down and to have it kept with him. Now, in the beginning, it was commanded by Allah subhanahu wa ta'ala. It was prescribed. And when Allah subhanahu wa ta'ala uses the word kutiba in the Quran, this is a strong prescription, right, regarding serious, important matters, like fasting, for example, or qisas, for example. So in this case, kutiba alaykum idha hadara ahadakum al-mawtu in taraka khayran al-wasiyyatu lil-walidayni wal-aqrabin bil-ma'ruf. Allah subhanahu wa ta'ala says, Surah Al-Baqarah, it is prescribed for you when death approaches any of you, if he leaves wealth, that he makes a bequest to parents and next of kin according to reasonable manners, and this and this is a duty upon the muttaqeen, upon the pious. So the commentators of the Quran, they explain that initially only the children had fixed shares in inheritance, and not the other relatives, just the children. And therefore Allah subhanahu wa ta'ala had advised that when death is near, you should write down some share and bequeath something to your other relatives, particularly your parents and other relatives, because they did not have a fixed share. But this is something which was later on it was abrogated. But the scholars explain the part that stays is that you are still allowed to give to others, meaning those who are not your inheritors, because in the Quran Allah subhanahu wa ta'ala has described all the categories of inheritors, and this is something which has been made mandatory by Allah subhanahu wa ta'ala. Okay, this is from the boundaries and the hudud of Allah subhanahu wa ta'ala, and it is not something which can be played around with. So this is the first thing to be very, very clear about, that when it comes to inheritance, when it comes to who gets what of our wealth, this is not something that is up to us when it comes to our immediate relatives. We do not have that choice anymore. Before, initially, it was possible because, like I said, only the children's share was fixed and the rest was up to the individual. But now that is not the case, because Allah subhanahu wa ta'ala has revealed, particularly in Surah An-Nisa, ayah number 10, ayah number 11, and other verses as well, Allah subhanahu wa ta'ala has defined every single share for spouse, husband or wife that you leave behind, for children, for parents, for brothers, sisters, right? And the whole system has been revealed by Allah subhanahu wa ta'ala. So now there is no choice in that matter, because Allah has not left it as has not made it optional. Allah subhanahu wa ta'ala has not made it optional. He said, wasiyatun min Allah. Allah subhanahu wa ta'ala has said that this is a commandment from Allah subhanahu wa ta'ala, right? So there's no choice now to say, okay, yes, Allah has said this in the Quran, but I want to do something differently. I don't want to leave according to the same shares for whatever reason, right? It has been mandated and clearly mandated in the Quran, so this is something that needs to be done. So there's no choice when it comes to your inheritors. Okay, there's a few conditions. Okay, so for example, they have to be Muslim, in order to qualify for a share, right? That's from amongst the conditions. So, some basic conditions. But apart from that, every single person is going to get a share. Sometimes, people get upset. Okay, they get upset at their child. And they said, okay, you have disobeyed me, so now I'm cutting you off from my inheritance. You can't do that. You can't do that because it's mandated by Allah subhanahu wa ta'ala. Or somebody says that, okay, the distribution of the shares that Allah subhanahu wa ta'ala has given, this is something that, I don't agree with. Okay, the times have changed. So for example, يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ. Right? Allah subhanahu wa ta'ala makes it very clear. He starts off, right, in Surah An-Nisa, when this part comes, Allah commands you regarding your children, the share of the male will be twice of the female. Okay, Allah subhanahu wa ta'ala says it very, very clearly. Okay, so somebody may say, well, I don't really like this. I don't want to follow this, right? So in this matter, this is an injunction from Allah subhanahu wa ta'ala, and there's no choice. Now you may say, okay, well, women might ask, daughters may ask, why is it like this? It doesn't sound fair. And yes, remember, Islam is based on equity, not equality. Because if you force equality, then what happens? You end up getting, you have equality, but it's not equitable. Yes, you get equality. So you say, yes, it looks the same. Right, you're a human rights lawyer, mashallah. Yes. So you get equality, but then you don't have equity. Is that right? Yes, that's correct. Alhamdulillah. I didn't study law, by the way, but yeah, alhamdulillah, I have the approval of the lawyer. Inshallah, 2 lawyers, mashallah, here. So it's not equitable. Why? Why is it not equitable? Because the male in Islam has greater responsibility mandated by Allah subhanahu wa ta'ala, right? Whereas the female is not required, right? When the girl gets the share, which is half of her brother's share, that's for her, for herself. She's not required to spend on anyone else. She can keep it all for herself. She can invest it, she can buy jewelry, she can buy property, she can do whatever she wants. That's halal. Okay, she's not required to spend a penny on anyone. Whereas when the male gets the share, he's responsible for his children, for his spouse, for his parents, right? So if we say that it's equal and it should be equal shares, then that's not equity, right? It's not equitable. So Allah subhanahu wa ta'ala is always fair, and Allah azza wa jal never wrongs, never oppresses anyone. So this is from the wisdom of Allah subhanahu wa ta'ala. So the point was that we cannot change, we cannot mess around with these shares. These are mandated by Allah subhanahu wa ta'ala. So this is why the scholars say, actually it's interesting, if you read the fatwa, right, if you read the edicts, if you read the fatwa, especially from scholars who are not in the Western world, right, they're in the Muslim world, then they'll say that writing a will is actually optional. Writing a will is optional. Why? Because in Muslim countries, right, it's understood that you're dying as a Muslim, right, and you're or the understanding at least was, I don't know what the case is in each Muslim country, but the understanding would be originally that because you're dying as a Muslim, of course your inheritance will be divided up according to the Sharia, right? There's no question about it. So they would say, actually, if you read those fatwas, it says that it's actually optional to write a will. You only need to write a will if you're going to be giving something extra. Okay, and I'm going to get to that in a second. But here, living in the Western world, that ayah of Surah Al-Baqarah, where Allah subhanahu wa ta'ala originally made it, encouraged or made it mandatory to write a will, that sort of applies to us at that level. Why? And, Brother Umar will explain, inshallah, that what would happen if you don't have a will? What will happen to your wealth and how will it be distributed? So that's why it is so important for us as Muslims who are not living in an Islamic system that we have a proper will, so that when we do die, there is clarity on how our wealth is supposed to be distributed. Okay, so I already mentioned the shares are mandated and there's no choice. However, there is choice in one matter, and that is that Allah subhanahu wa ta'ala has allowed us choice in 1/3 of what we leave behind. The totality, whatever our entire estate is, the entire amount of the inheritance of all of our wealth collectively, from that 1/3 we are allowed to leave for someone who is not already an inheritor. So someone who is not already mandated to inherit from us. So it could be an individual, it could be an organization, it could be a charity. That we can do. Okay, so for example, when I die, okay, so my wife, my children, they all have their shares, which are mandated. I cannot decide that I want to give more to one of them. Okay, I can't say, okay, from my 1/3 that I have, I have choice, freedom over, I'll decide to give it to my daughter, for example. Or I want to give more to my wife. I can't do that because their shares are already mandated. But if I decide, okay, that I want to give 1/3 to the KMA, as an example, okay, hint, okay. So yes, I can do that, okay. Or I want to give it for any cause. Or I want to give it to my nephew, or I want to give it to someone who does not get a share. They're still a relative, but they don't have a share mandated. That I can do. Okay, so is that clear? So 1/3 can be given to someone else. So this is the second thing to note. The third thing to note is that we can't give any advance directives. Okay, what do I mean by advance directive? This is a term, by the way, used in MAID, medical aid in as medical assistance in dying, right? But an advance directive, essentially, in this case, what I mean is someone says that, okay, this is my property right now, but what? So, for example, I have a house or I have a piece of land. It's mine, but after I die, it's going to go to such and such person. Okay, I can't do that. I don't have that choice of deciding that after I die, who it's going to go to. Okay, whatever is left when I die, it's all part of my estate. It's all part of my inheritance, and it all has to be divided according to the laws of Allah subhanahu wa ta'ala, except for that 1/3, as I already described. Okay, so this is not something, and it creates so much confusion, subhanAllah. I've seen this in families. Right? So my grandmother, my grandfather said that, when they pass away, it's going to be, my grandfather said it was going to be my grandmother's, who happened to be a step-grandmother, so it was supposed to be hers, but it was originally his, but when he died, it became hers, and now, she has kids, and he had kids. Like, oh my goodness, it's a complete mess, and this is why you need the lawyers, right? So, just to be very clear, there's no advance directives in terms of saying what's going to happen when I pass away. When I pass away, what's supposed to happen is already decided by Allah subhanahu wa ta'ala, except for that 1/3, which I already mentioned. So this is another very, very important point to note. The last thing I would mention is that all of this giving of if we want to give wealth, okay, so somebody decides, what, I don't want to wait, or I don't want to leave it for when I die. Because, at that point, who knows, my kids are going to be fighting, and I don't want to, have that mess after I go. So I'm going to give it in my lifetime, okay? I'm going to distribute it in my lifetime. So when we distribute in our lifetime, we can do that. So whatever wealth we have, we can decide whatever portion of it, we can decide it to give it to our relatives, give it to whoever you want. There's no restriction on that. Okay. The only thing I would say, though, is there is, a hadith of the Prophet ﷺ that indicates that if we give to our children during our lifetime, then we have to be fair with them. Then we have to be fair with our children. We should not be favoring one over the other. Some scholars say that, okay, if there is a really legitimate reason, like a logical reason for giving more to one, and it's not simply to deprive them, but there is a real reason for it, then perhaps there may be some exceptions. But generally, we should ensure that we are fair with our children when we are giving our wealth away or we're giving them a gift. And this is two different things. So if we give in our lifetime, it is hiba, it's a gift. And if it's given after we die, then that is not a gift. That is part of our wasiyah, part of our bequest, and it has to be according to the laws of Allah subhanahu wa ta'ala. Now, in terms of, what should be in the will, Islamically, so the will, should talk about a few things. So number one, it should talk about the payment of debts, right? Because this is a very serious matter. The processing of a soul, you could say, it's going to be held up if there's outstanding debts. Right? This is why sometimes you'll see at the janazah, at the prayer, the son or someone will come up and say, if my father had any debts, if he had any dealings, and he owes you anything, then please let me know so that I can pay it off, right? So one of the key things that the will should do Islamically is talk about the payment of debts, right? So those are cleared up. Secondly, funeral expenses, right? And sometimes people ask, okay, so, I've been getting a few calls, how much does it cost to have a burial, here in Canada, in Ottawa, right? So I think it's in the range of, at last check, I think around $3,000 to $4,000 probably. And these are, obviously simple funerals. It's done in an Islamic way. So that's, so that would be taken first from whatever has been left behind. So the payment of debts, the covering of, of funeral expenses, also, the what's it called? When it comes to custody of children, that's a very, very important matter, and Brother Umar is going to talk about that, inshallah. And then the rest is the distribution of the wealth and distribution of the shares and how it is to be done, and that is all to be in the will, inshallah. Okay, so I'm going to leave it there, pass it on to Brother Umar, inshallah, and afterwards, if there's any questions, we can answer them to the best of our ability, inshallah.
Assalamu alaikum. Can you hear me good? Perfect. Jazakumullah khair. to be here tonight. We're talking about a very important matter. It's a will. Just before we get into it, as a lawyer, we have to give a disclaimer. So no information construed as a legal advice. It's just for educational purposes. If you have any question, concern, you can talk to any lawyer. And then one thing, it's very clear, so many people have doubts. Before I start this seminar and all that stuff, nobody need a lawyer to make a will. Nobody need a lawyer to make a will. You go to lawyer if you want to avoid any issues in the will. So I will talk about this more while I move forward. Okay. So what is a will? A will is a document which expresses a competent person's vision about the distribution of his/her testamentary assets on death. It may also include nominate an executor, appoint a trustee, appoint a testamentary guardian, express wishes for the disposal of his/her remains. And who is a testator? Testator is a person who makes the will. If I'm making a will, I'm a testator. These are the legal language I'm telling you. If I'm the one who's making a will, I'm a testator. Legally speaking, I have to be 18 years of age to make a will. I have to be sound mind and have testamentary capacity. This is where, when we see a client, we ask about the assets, we ask about his overall health, we ask about his overall circumstances, his job and everything, just to make sure that he has the capacity to give some instructions. Must be capable of appreciate his/her assets. He knows what assets he have or she have it and where are they located. Will is a provincial matter, so it only covers Ontario assets. If you have a property in Alberta or maybe in Quebec, then you need to have a will in that province. So key points, it covers your burial instruction, it trustee with or without a compensation. The trustee is a main part of the will. So basically you appoint someone to follow your direction in the will. So that trustee can be with or without a compensation. Succession Law Reform Act, which deal with the will and power of attorney, give a fairly compensation guideline in the act, or you can appoint it. Guardian for children, if there is no guardian, then a court can appoint a guardian, or you can appoint a guardian in your will. Specific bequest, if you want to leave something very specific to any child, this car goes to my son, this jewelry goes to my daughter, then that is a specific bequest which we deal with before we distribution of the assets. Once that done, then we go to distribution of the assets, called as residue. Executor or trustee, the trustee must be over the age of 18, sound mind, person you trust, mostly are family members, mostly one spouse is a trustee to the other spouse, or elder child who is 18 years old, normally a friend or family member, or try to appoint someone residing in the same jurisdiction. Otherwise, the court needs a bond to be fulfilled before they can act on that. So if you are having a trustee who is residing in USA, somebody's brother living in USA, so if they come and execute your will, they have to put a bond in place, double the amount of the will.
What does that mean?
Meaning that if your asset come up to $500,000, court said that you're not a resident of Ontario, so you have to put $1 million in the court to deal with the assets of that $500,000 estate. So to overcome that, we normally put a clause in the will to avoid that part.
But so just to be clear, that a bond doesn't mean that you have to put in $1 million in cash?
No. It's just a security you have to give.
Right.
Yeah.
So it could be property, right?
Exactly. Yeah. Guardian for children. Until you get the certificate of execution from the court, maybe for a month, maybe for 3 months, maybe for 6 months, depending on. Just court need to satisfy itself that this is a right person dealing with the right assets. So guardian for children, a person you appoint to take care of your children who are under age of 18 if both parents dies together in tragedy. If no guardian is appointed, then a judge at the family court will appoint a public guardian for the children. Mostly your friends or other family member come forward as offer themselves as the guardian. Judge can consider them but not bound to appoint them, because the judge only consider the best interest of the child, not the best interest of the trustee, not the best interest of the guardian. So if the judge thinks that this is not the right person, then judge can decide whoever the right person is, if there is no instruction in the will. Guardian for children, By making a will, you can make an appointment in your will, and this would be overriding factor in the judge decision. So judge now knows what do you want to do and what is your wishes. So most of the time, wherever there is a myth going on that if you don't have a will, government will take your money, government will take your kids. This is wrong. It doesn't work that way. So judge always look for the will. If there is a will and you appoint somebody, judge always respect that decision. If spouses are divorced and the spouse who has the legal custody of the child has authority to appoint custodian and a guardian for his or her own preferences. So if there are two persons who divorced, one person have a custody of a child, the other has only visitation. The person who has a custody of a child, if she or he dies, he has the power to give guardianship to anybody else other than the original father. So that is a big thing. So that if somebody getting divorced, so custody is the main thing people are fighting for each other. So this is one of the reason why they need custody of the child. I think at the end is better. Yeah, if you can, yeah, no problem. So limitation on will. So Succession Law Reform Act have some limitation on the will. Support of minor children, entitled if not adequately provided for your will. So this means that who can challenge the will? The children, the beneficiary can challenge the will. Anybody who is depending on you can challenge the will. Your parent can challenge the will. Your neighbor sometimes can challenge the will, saying that I'm helping this person for last 20 years and then now I need some compensation. Or sometime you promise somebody that okay, I'll give you this much money and you forget and you died, and people claim it that he promised me to pay this much money but he never paid, so he can challenge the will. And in the Family Law Act, a spouse can challenge the will. This is the important thing, most people don't know it. So in will, if you leave spouse anything, let's say $10,000, $50,000, $100,000, and spouse is not happy with that decision you leave in the will, under the Family Law Act, spouse can choose to elect an election under the Family Law Act and go for $350,000, and court can give this much money to the spouse. If this is any spouse, like not husband or wife, any spouse. So this is one of the factors when somebody come to make a will with us, we just tell them this, you have to talk with your family first, your kids, your family knows what are you writing down. So if you're giving your spouse, whatever you want to give your spouse, make sure that your spouse knows what are you giving to her or him, so they cannot challenge it. If you leave your spouse, let's say $10,000 out of your $500,000 assets, the spouse has a right to choose $350,000 out of the residue, not the $10,000. So it's a big thing. Some people don't even know about it.
So is the 350 a fixed amount?
Yes, 350 a fixed amount, and then she have a share on rest of the amount. So I'll give you an example right now and then move forward. So if you have the whole residue is $500,000, and spouse is not happy what you left for her or him in the will, so she go with FLA, Family Law Act, and she get the 350, and then she get half of if you have one child, or she get 1/3 if you have more than one child, and then the rest of the children get 70% of that remaining portion. So out of $500,000, spouse will be getting about $400 to $425 altogether when you are giving her $10,000 or him $10,000. So this is the main thing, that whenever you make a will, just make sure that your family on board, just your children, your spouses are on board. They know that this is, if you want to make Islamic will. So this is something you need to talk with your family first before making a will.
So Islamically, every inheritor is entitled to whatever their share is according to the Sharia, right? So if somebody is leaving less than what they're entitled to under the Sharia, then they can certainly avail of this and get their rightful Islamic share or rightful share based on the Sharia, certainly.
The numbers you were mentioning, are they Canadian law numbers, the 70% and whatever numbers you mentioned?
No, I'm just giving example right now. But $350,000 is an amount which Family Law Act gives a spouse. If that assets are there, then the spouse can go up to $350,000.
But that's separate from the Islamic number?
This is no, I'm not talking about Islamic right now. Imam Sahib have already explained the Islamic side. I'm just explaining the Canadian side right now. and then we see how we aligned both of them after question answers. Yeah. So to be valid, a will has to be meet certain formal requirements in a way that it is signed and witnessed. The will has to be signed and witnessed in the presence of two witnesses, not one. And that witness, if a document is not validly signed and witnessed as a will, it can only be will if the court makes a determination. Okay, there's a flaw. There is only one witness to sign. Then it's a judge decision. He can or she can say that this is a will is valid or not, depending on the factor. But law requires that the person signed in presence of two witnesses, and all three people are signed together at one time at one place. You cannot just sign documents, send it to somebody else out of the city. They sign it, they send back. In COVID, they lift a little requirement, but now it's back. So the document has to be signed in all three people presence at the same time. This is a requirement. Why make a will? Yes, if you don't make a will, the law of intensity will decide how your property is divided and who will receive it after that. Trustee can deal. So what it means that if you don't have a will, the first right of the residue is your spouse. If you have a spouse, everything goes to the spouse. If you have a spouse and a child, so again, up to 350 goes to the spouse, and rest, the spouse and child will do half and half with the rest, whatever is, if there are any rest. If there are more children, then those children will divide each other the remaining out of 350. And if there is no spouse, no children, then this goes to grandchildren. If there is no grandchildren, it goes up to the parents. If there is no parents, it goes to the brother and sister. This is the intensity law here. If you don't have a will, it automatically decided. Judge can just give it this way. So trustee can deal with that. If you have a will, the benefit of that is the trustee can deal with the assets of the estate immediately. Instead of an intestacy, there is no person who can act immediately. Someone must apply to the Ontario Court of Justice to be appointed as a estate trustee. So that takes time. It takes about 6 months or sometime a year right now. The courts are very backed up right now. So if you have a will, at least you can give a copy to the bank. You can give a copy to the lawyer. Start processing it. But if you don't have a will, everything stops there. You cannot go to bank. You cannot go do anything. So you have to go court. You have the wife or a kids or anybody else can go and present a case in front of the judge and ask them, please nominate me as executor, so he can start working on it, and that consume a lot of time and a lot of money. Some of the people you would like to provide for many may receive nothing or may end up applying to court for provision of your estate. You will not have a say who is to be trusted to deal with your assets after that, because the court appoints the administrator, or if you have children under 18 who should be their guardian. So this is a court discretion again if you don't have a will.
So essentially what you're saying is that if you don't have a will, you're leaving a lot of major decisions up to the court.
Up to the court, exactly. They just open the Succession Law Reform Act, follow the rule, and then appoint it.
And your wealth is going to be stuck until
exactly
something, and that takes time up to 6 months.
Exactly. And first of all, whoever going to court without the will, they have to prove their relationship with this person. So this is the main thing too. Sometimes people don't have a direct relationship, so that even delay the process.
You mean like birth certificate?
Exactly. So all that things. With the will, you can bypass all that stuff, because judge already know who you want to be as your trustee. Yes, they can keep it there. They can stay there, no problem at all.
No, but can they take money from the bank account?
It depends on the bank to bank. Yes, some bank, if you take it to the original will, they can release the money on the you see your IDs, you're a spouse, yes, that's fine. But some banks say, no, you have to go and get a probate. Every will has to go and get a probate if it's more than $50,000 per will.
So can you explain what a probate was? Because I had no idea either.
Yes.
You told me the other day. So.
Probate is a process to appoint an certificate of executor. So every executor, every trustee take the will to the court to get a certificate. So that certificate is a proof that everything is fine. Now that certificate can be deposited in the bank, can be deposited in the land registry office, can be anywhere. So that is a certificate which judge will issue with or without will. If you have a will, you still need a certificate. If you don't have a will, you still need a certificate. I'll come back to your question after.
So essentially, just to clarify, any person who dies, right, like every person who dies, in order to touch their wealth, you need the certificate, right?
Exactly.
So everyone, for any
Will
relative,
or no will,
one
it has to
person
go.
at least has to go, the executor has to go to the court and get the certificate, and that certificate will then allow you or allow them to be able to deal with your wealth.
Exactly.
And if there is a will, how much time it takes for certificate?
If it's a will, right now it's taking about 4 to 6 weeks. And you don't have to go in front of the judge. If your file is complete, you go to Ottawa Courthouse, 161 Elgin Street, you deposit it there, deposit the fee and all that stuff, and then it takes 4 to 6 weeks. Most of the time with the will, judge don't even call you. But if there's no will, judge can call you anytime they want to, just to get more evidence or corroboration. So what happens if I die without a will? Does the government distribute my property according to their rules? No. They still wait for it to somebody come up, somebody try to see. If nothing comes up, that there's a rule that they waited for 21 years, I think so, and after that they take the property and become as a government property. But they wait until, I think so, I'm not sure how many years, but it seems like it's 21 years. If nobody claimed that property, and if nobody claiming that money, then it becomes. Again, if anybody comes after 21 years, they can go to court and get that back, but obviously they cannot just leave everything right as it is. The person who had it will have to go to a lawyer, and the lawyer will make an application for executor to be named, and the executor will then transfer the property according to the inheritance rule. A lot of information has to be provided, including a list of assets and value of the assets, fee based on value. So who can be a witness? Who cannot be a witness? So this is a very important thing. Most people don't know it. You make a will at home, you ask your spouse, can you please witness me? And you think it's a will? No. Any beneficiary or a spouse of beneficiary cannot witness your will. Is the law. The moment they witness your will, it is not a valid will. It is not a valid will. A minor cannot witness your will. A person must be a sound mind, knowing what he is witnessing.
And sorry, the co-witness should be alive during the execution of the will. So, for example, the padlock that two people sign the will and one of them passed away.
This is a good question. I have an answer for you. Just let me finish it and then I'll come back to you. But look, let me answer this right now because it's an important thing. So let's say I make a will and I have a witness A and witness B. Okay, now after 20 years, my will go to court to probate. So judge said, okay, go bring witness A or witness B just to confirm that they were present at that time with this person and sign in that presence. Okay, so make the will valid. So now my family go out and looking for person A and person B. Person A left the country, person B died many years ago. So now we have a problem. So my family have to chase the person A wherever he is. So he has to be contacted. He has to write a letter or something to the court that yes, this is true. But if he said no, I don't remember anything, I don't know anything, I forgot, then 90% chances is that the court will say that this is not a valid will. Again, if it's a small estate and every beneficiary on board and everything is fine, yes, court can make an exception. How we can save it? This is how we can save it. So we make affidavit of subscription of will. So whenever I witness my client's will, I make an affidavit that I, Mr. Imam Sikander, and the executor or testator was all present in my presence and sign in front of me. And I make that as a part of the will. So once that document attached to the will, meaning that judge do not need to call anybody in future. So that document is enough to provide judge evidence that this is being done properly. So you don't have to chase people. And I believe that there are many wills who don't have these documents with them. It is signed, it is witnessed, but when the time comes, sometime as a parent, I go to my friend home, have a sign, and give it to my kids. Kids don't know who my friend was. They don't know where he lives. They don't know who to contact after 20, 25 years. So these are the small things which are very important to consider, that those witnesses has to be located. If not, then that affidavit of subscription of will has to be attached with the original will.
Can we make it as notary and then we bypass?
Notary has no value in the will. I don't know why people talk about notary.
So let's answer that afterwards.
Yes, inshallah. Yeah. Okay. when should my will change? Okay, you have a will. Now, few things happen. You need to change the will, marriage or remarriage. You need to make a new will. Separation does not revoke a will, but if you no longer want your spouse to benefit, should be changed. Divorce does not revoke your will automatically, but if your spouse remains, the law assumes that you would no longer want your spouse to benefit it. Death of a spouse, acquired considerable more property upon the birth of new child or when child become the age of majority. Something like this, I believe, yeah, you need to change the will or make a new will because these are major changes in your life. Problem with signing and witnessing. To be formally valid, a will must be in writing. First of all, you cannot just say that, okay, this is my will to somebody orally. It has to be in writing. So while I can stop here because I can explain a few more things. There are two types of will. One is handwritten will called holographic will. You just write with your hand and then sign it, no witness required. I again say no witness required if you write by your hand. But if you type your will through a process, then you need two witnesses. Equally important that holographic will has more challenges to be a probate in the court. For the same reason, judge need to know, is that person really signed this will? He write this will. So he gonna call upon many witnesses to confirm that the person's writing is the same or not. So again, it's an issue. But yes, you can do it. A will must be signed by the will maker or by someone else at the will maker direction. Sometimes people are blind. They don't know how to sign, or sometimes people are, God forbid, no hands or something like that. So they can present, you can read the will, and they can say, okay, my friend so-and-so will sign on my behalf. This is possible. And then we make an affidavit that the testator is here, I'm here, with on his direction and authorization, this person signs as the witness or the executor. The signature of the will maker must be made or acknowledged in the presence of at least two witnesses who must sign the will in presence of the will maker. The two witnesses must both present at the same time to witness the will. Witness do not need to know the content of the will. You don't have to read your will to the witnesses. They don't need to know. You can tell them you can sign here, that's all.
Sorry, very quickly. Do they need to initial on all the pages?
Yes, this is recommended. I always have initial on all pages, but it is not required. This last page has to be signed. This is a requirement, but I always have initial, so there is something not added in future. Problem with signing a witness will kit form filled out but not signed or witnessed properly. Sometimes people filled out the form, have it stored without doing that or without noticing that it is not signed or witnessed. A will has been altered and alteration has not been signed and witnessed. Sometimes somebody cut down the property address, write a new property address, and then they forget about any initial or signing again. The will refer to list, but the list has been changed since the will was made and the list is not signed or the witness. So try, if you're making a will or something like that, do not put any current addresses. Okay, my home so-and-so on this so-and-so street. So what happened if after 2-3 months or 2-3 years you sold the home? And on your death, you don't even own that home. How can you transfer that home? So these are the small mistakes which will, if not voided, delay the process.
By list, are you referring to list of accounts?
Yes, you can put a schedule at the back of the will. Yeah. One of the witness is an intended beneficiary under the will. The problem with identify who gets what. So sometimes people give out what they don't even own it. Why I'm saying that, I'll explain you maybe on the next slide. So problem with signing and witness. In a will, it is important to use language that is clear and unambiguous. It should be capable of being understood by someone who does not know anything about the will maker's circumstances. If the wording in a will could have more than one possible meaning, an application need to be made to the court, decide who the will should be interpreted. Example problem, gift to my family. Who is the family? You have to identify my spouse, my kids, give their names. Gift to my niece and nephew. Does this include children on half brother and half sister? Does this include niece and nephew of the spouse or de facto partners? Gift to the certain charity, religious or non-profit. So I make wills every day or twice a week something. So people said, okay, I want to give $10,000 just saying the KMA. KMA is not enough. You have to go to CRA website and get the charitable number of the KMA and the full name of the KMA, and then write their name. Just KMAs, maybe there are 10 more KMAs. So it's a confusion.
It's a Canada Music Association too, by the way.
Yeah. So there you go. So you have to go CRA website and look for the charitable, and good is if you can put address of the charitable too. So sometime with homemade wills, the will maker will instruction violate the public policy. So you said, okay, I will give this to my kid if he never marries. It's against the public policy. So you cannot stop somebody to get married. So that will be violated. Residue does not distribute property to children or their issues. So I give everything to my child. What if your child dies before you? Then it's a problem there. You never mention who it goes to. Give away the assets owned when the will was made. For example, a house and bank account, but will not say who is to receive anything else they may own when they die. Leave everything to one spouse, their spouse, but fail to say what should happen if the person dies before them. Same asset, jointly held property. This is the main thing I want to talk about it. So most people have 1, 2, 3, 4 homes, whatever. Let's say a person have one home. And I'm a real estate lawyer, so that's why I know this problem. So when you take a title, they ask you what is your capacity to take a title. So are you a joint tenant or tenant in common? So joint tenant means has a right of survivorship. So many people take property with their friends, with their brothers as a joint tenant. So if I have a property, I buy it with my brother as a joint tenant and I die, before I die, it automatically transfer whole to my brother without coming into will. People don't even know it. So you have a will saying that my property goes to my wife and my son, but your property has already gone to your brother under a different law. So you don't have anything to give it to your spouse and your child. So make sure that if you have a property or anything that is a joint tenancy with anybody else, that has to be severed and that has to be in tenant in common. So tenant in common means it fixed to your share. It becomes your estate. Right of survivorship means joint tenancy is automatically, doesn't matter, you have a property with your friend, your brother, your niece, anybody, it automatically transfers to that person on your death. It will not become a part of your estate. That's the main thing. Many people don't even know about it.
So just to make that clear, there's two ways that you can own a property together with someone, right? So the first one is joint tenancy, right?
Yes, joint tenancy.
And in a joint tenancy, if one of the owners dies, the entire property goes to the other owner. It will not be distributed as part of your share. And most people, I think, right, when they're doing real estate deals, especially husband and wife, normally it's joint tenancy.
Exactly.
Right? So legally, it will automatically transfer, and nobody else will have a share, no matter what your will says, right? The other is
tenant in common.
Tenant in common. There, the shares are fixed. So it's 50% and 50%, as an example, if there's two, right? So it's very important that when you're buying property, you pick the right one, or you know the difference between the two, because when something happens to one, it's gonna impact the other in different ways.
So if somebody come to us for buying a property with his friend, because many times there's a mortgage issues, there are many issues, people need to have their friend, family member on the mortgage as well. So whoever on the mortgage has to come on the title. So we tell them that why don't you put this person as a 1% tenant in common and get the 90% on your own. So, and sometime we do with the parents buying for their kids, something like that. So that saves that person from this issue. So many wills are because when they come to the issue, there is no property to give to their estate because it's already been transferred to somebody else. And many people even don't know when they're signing the document home, what are they signing. So please read it when the lawyer is explaining you the home document. If you're buying a home, tell them what are the capacity you're mentioning here. So this is a probate. Probate is it's a requirement what need to be get document probate. Original will or confirmation of no original will. So original will has to be there. So make sure that your will is not lost or destroyed. If the deceased had a will, provide the original signed copy. If they did not, provide confirmation that they died without a will. That certificate you needed, the Ontario Superior Court of Justice will request a proof of death from the funeral director instead of government-issued death certificate. Information about the deceased, information about the executor, and bond, and this is required when. So this is a long list of the documents you need to probate a will. So every will go through this. But if you have a will, then half of the stuff has already been done in that. You don't have to explain the relatives, you don't have to explain anything because the will already explained it in itself. Problem with storage and security. Mostly people don't know how to secure the will. They put somewhere in just to always keep the will away from water and fire, because these are the only thing which can destroy your will forever. If you make your own will, be aware that there are many problems with the will. The problem may not be discovered until it is too late for you to fix it. In most cases, it may be necessary to make an application to the court to resolve the problem. There will be delay in relation to sorting out affairs after death. There will be uncertainty about how your estate will be distributed. Your estate is likely to have to pay substantial legal costs in order to resolve the problem. So make sure there is no problem or very little problem in the will. Other things to consider when making a will: specific bequests and residual estate. So you have to be very specific. If you want to give a very specific bequest to one child or anybody else, make sure that your residue is enough to cover the other children. Do I want my child's spouse to inherit? This is the main thing. This is the main thing. In a will, we stop it there. We have a clause, we stop it there. So let's say you have a daughter, you have a son, and then they inherited from you and they're married. So the will says that inheritance will not become part of their family net property. It will go to her or him alone. So if that clause is not there in the will, it automatically becomes. So let's say on December 1st, a couple has $50,000 of assets. December 5, the guy or the girl's father died and gave them $5 million. On December 6th, they both own a $5 million if this clause is not there. But if this clause is there, only the girl or the boy have that much money. It will not be shared with the other part. So this is a very important thing. This has to be in the will, so it stop making their family property. This is, we drafted a clause that stops the inheritance to the child, not making their family net property. So if, let's say, if God forbidden, the person dies on December 5, I'm just giving example, okay, again. December 6th, both are become $5 million. December 7th, he cannot get divorced or something happens. So that's the reason we stop everything to the child who's inheriting it, even she or he is married, and then he or she can decide if they want to share that inheritance with other partner.
What is the term that you're saying? Is there a specific term?
No, there's no specific clause.
There's
They
no,
just add that.
we have it, we drafted it in our wills. Yes, this is.
So does this mean that by law automatically
Yes.
inheritance becomes common?
Yes, if the clause is not there, it automatically goes. So we stop it there with the clause saying that this is a clear instruction to the trustee that this is only, and confirmation is required from the spouse, the child, that she's not going to share, he's not going to share. So this is what we add in the will. So what, I think the battery is going down, I don't know. What should happen if there is a common disaster affecting you and your spouse together? So what happens if, God forbid, somebody have 2-3 small children and your spouse all together is wiped up in a plane crash or car crash, something like happen? You have to give, we call it wipeout clause in our will. So we said that if none of us is surviving on the day, then mostly people said, okay, divide it equally between mosque, or give it to my friend, he helped me a lot. Then we have to include something like that instruction. So if I had property in another country, could this will be valid with regard to property located elsewhere? No. It is only for Ontario properties.
Does the will get registered with a lawyer or something, and the original is with the person?
No, what we normally do,
Only, or is the
We could answer this afterwards, inshallah.
yeah, just a moment. So probate, this is an application to appoint a state trustee with that will. So how to save probate fee? Talk to a lawyer or accountant. They can tell you, because there is a probate fee, 1.5% of your assets. So if you have $1 million assets, there is a probate fee of 1.5%. So you're paying almost $14,000-15,000, something like that. So which thing you don't pay the fee if you have a home which is $1 million and you have a mortgage which is a $500,000. So the mortgage is probate fee free. So the rest you pay on the rest. So the value is $1 million, but there's a mortgage of $500,000, but you pay probate on only $500,000, not for the $1 million. That's the only thing where you save money on the fee. Otherwise, no. And more thing is that mostly people include life insurances, RRSPs, RESP in their will. Do not do that, because they have their own beneficiaries, let them go directly out of the will. Whatever comes in the will become your estate, and you're paying taxes on that. So do not, if you have a life insurance saying go to my spouse or go to my child, let that go. Don't mention that in your will. Whatever you mention in the will, that becomes your estate, and you pay probate fees on that.
It's not mentioned in the normal life insurance that the beneficiary statement will allow that fund to go straight without taxes?
Yes, there's no tax if it goes straight.
If they're already listed as the beneficiaries, RESP or
Yes, exactly.
Any registered amount, you don't have to mention it.
In the will, no, you don't have to mention it.
RSP, RIF, RESP, TSFA.
I can check it, but no, you don't. If there's a beneficiary clause there and they can pay directly to the beneficiary, yes, it directly. You don't have to include in the will at all. So then there is we already done about the will. Now I'm talking about power of attorneys. Power of attorney is as important as the will is. The only thing is that power of attorney is come into effect when you are not capable of doing your or managing your property or your personal care. But these documents has zero value once the moment you died. But the will can only kick in when you die. Before you die, even you are in coma or something like that, the will has no value. You can stay in coma for 10 years, will is not implemented. The moment you stop breathing, then the will kicks in. Before the will, you need to have a power of attorney. So if you are with a doctor and you are not capable of giving any instruction, then this power of attorney document is very important. You have to. Sometimes they don't even listen to your spouses. If you go to hospital and spouses try to give any instruction, they said no. Go to court and get yourself appointed as a power of attorney for this person and come back us and then give us the instruction. Many times it happens, and then these documents are important. So who can be an attorney and with what are the requirements? Your attorney must be adult, sound mind, a friend or family member, can be more than one attorney, requirement be signed by you and dated, be signed by two witnesses who saw you sign the document as same as the will is. This is a power of attorney. This is when you're alive, but you cannot provide the instruction. But will only kicks in, God forbid, when you died. It is silent before that.
Power of attorney, you need two witnesses.
Exactly.
The same way.
The same thing to make it valid. I think that's, and thank you for everyone who attended the seminar.
questions. So we'll start
Yeah.
with the sisters because I know there were questions and we didn't take them. So
Legally speaking, not Imam Sahib will answer for the Islamic side, but legally speaking, you have to be 18 before any will you make for 18. It is not valid. Only people who are in military, they can make a will at age of 16 sometimes because they are on the mission. Sometimes they don't know they're coming back or not. That's the only exception in Canada for them. But anybody else has to be 18 years of old.
yeah. So of course, like any other matter, Islamically, of course, there's no such thing as or the age of majority is really puberty. So once a person is baligh or baligha, then they should, especially if they have, if they have wealth. But I guess legally, if a child, meaning legally a child, someone who's a minor under 18, were to leave instructions in a will, like a court would not honor it, right? So, yeah. So here's the thing, right? So Brother Umer mentioned something that's really important, and that is to have this conversation with our family members and have them on board with whatever our wishes are. So if you want your wishes, like if your wishes are according to the Sharia and you want your wealth to be distributed accordingly, then let your children and let your spouse know, let all your inheritors know that that is the way you want it to be done. So then, even if, let's say you forgot to write a will or it couldn't be found or whatever, and your estate is distributed legally, okay? So there's no Islamic, there's no instructions according to the Sharia, and Ontario law is being followed, okay? And the court, distributes the wealth according to, orders that it be distributed in the way that the Ontario laws say that it should be. Those inheritors could decide amongst themselves and say that, no, we want to distribute it according to the Sharia. So they'll take whatever is given to them, but then they'll redistribute it within themselves if they all agree. So that could still be done, right?
Yes.
So that could be done. So the key there is really having your family members on board and getting them to understand the importance of this and telling them how you want it to be done. Another thing I want to mention is that, sometimes people say, okay, you're traveling tomorrow and you're like, oh, I don't have a will. So let me just, grab a piece of paper and just say that, I want my wealth to be distributed according to Islam. Okay? Or according to Sharia, right? So that's not going to work, right?
No.
You know, so when you try to get a probate, like, it's not going to be considered to be a will.
Yeah.
More questions,
Yes,
inshallah?
Imam.
Somebody who hasn't asked. Dr. Nabil, go ahead.
Waalaikum salam.
I'm trying to write a will to be compliant with the Sharia at the same and to be not complicated.
Okay.
Now I understood from your presentation here, I put beneficiary for RRSP, for ERSP, and TFSA. It's better to have a beneficiary rather than putting to the state because I'm going to pay tax.
Exactly.
Now, when I'm making, for instance, my oldest daughter as a beneficiary on all my bank account, on TFSA, RSP, even if verbally I have with her an agreement that after I die you should divide it according to the Islamic Sharia, but legally when she's the beneficiary, she's the owner of this wealth. Do I have to write a written agreement with her that after she gets all this wealth she has to divide it according to the Islamic Sharia? Or should I leave that to her conscience, which is I'm giving her a lot of responsibility when she has a lot of money?
Yeah, main thing is that you can leave it to her with the conscience that she can do whatever you are instruct to her, but you can have a contract, or you can talk to the see if they can add more beneficiaries. If you have 2-3 kids, you can say that divide equally in that part and then do it. Or the other way is put in the will, and then you have to pay 1.5% fee on that.
Or it's better to do it beneficiary and have a contract done at the lawyer. So
I don't know how that contract would be enforceable. I can look into it. I haven't done that type of contract yet, but yes, I can look into it, how that contract, but any two people, sound mind, can do any contract they want to as long as it's not illegal.
So, I mean, I think so the thing is that in this, let me just put it simply, right? I think, correct me if I'm wrong, 2 lawyers here, mashallah. If it's not in a will, there's a good chance that, like, you're leaving it to really, her conscience. If you trust her, inshallah, but it's not secured. Let's just put it that way, right?
from Islamic perspective,
Yes.
isn't it forbidden to give a child and not to give the rest? Because after all, just like I
Oh yeah, of course. So you would need to have it written down somewhere at least.
I put her as a beneficiary,
Yeah.
just like I given her.
Yeah. So Islamically, you would need to ensure somehow that she knows and the rest of the inheritors know that she is, like, they need to know what you're doing, right? And you need to give them written instructions, which do not need to be part of the will per se, but you need to have some sort of instructions that they can go by. The question here is, though, or the challenge here is that it's not going to be recognized officially, right? So it will still be up to her, because legally she will be the owner, to, in good conscience, divide it up according to your instructions. Right?
Can I add something, please? I think you can actually use other beneficiaries, and you can put the shares for each one. As I recall, I think I have done that.
This is what I mentioned first time.
Yeah, so that's what he was saying initially, that, you could, the first thing would be to see if you can add more beneficiaries and divide up the shares, right, or like the percentages. So that would be the best way to.
Imran bhai.
Okay, so maybe along the same line, then Imam Sahib can highlight that with the Islamic point of view here. So right of survivorship. So is it almost the same as the law of hiba, as I'm gifting someone? And since it goes to the person who had the right of survivorship. So would that be in violation of the Sharia in terms of the wasiya and everything? And continuing from the brother's thought, that beneficiary, wouldn't that be under hiba as well?
So,
Because technically speaking, during his lifetime, he's assigning that.
So here's the problem, right? So hiba is only a gift, can only be given during a lifetime, right? So if the individual is the owner until they die, and then so this is what I was referring to as advance directive, right? Essentially, so you're giving it a directive during your lifetime Essentially, that's what it is, right? To say that once I die, so this is mine until I die, and when I die, then I want such and such person to become the owner of this wealth. So, Islamically, that is not a hibah anymore. It can't be hibah because hibah needs to be done, gifting needs to be done while a person is alive. And by the way, I forgot to mention, it cannot even be done on the deathbed, Islamically, right? So before there's any indication of critical illness or anything that is likely to lead the person to die, that gifting needs to be done before that. Once the person is on the deathbed and death is expected, then that person really has no control over gifting at that point.
So in that way, is it correct to say that it's not permissible in Islam to nominate a beneficiary? We can give the power of attorney because that's when you're alive.
Yeah.
Legally, it kind of connects with that. So when we bring the beneficiary, either as somebody was commenting that maybe we put another instruction there where it says this beneficiary is only until I pass away. After that, my will take effect for that. Would that be correct?
No, let me correct it. Power attorney is not as a will. Power attorney is just you appoint somebody to take care of your assets, and then in your incapacity. So paying a bill on your behalf.
Connecting with the beneficiary part.
No. It is.
To beneficiary, would that be a power of attorney then?
No. Power attorney is just taking care of your assets. So if you cannot act due to any illness, due to you're away of the country or something like that, so what the power attorney can send, you're in Pakistan, you said, okay, Umar is my power of attorney, and then I want to sell a property. So I am here on your behalf, I sell a property and then put every single penny back into your account and let you deal with whatever you want to do. That's my job only in that scenario. So it is a totally different document, totally different purpose, totally different thing.
I will just take one very quick question. So that, maybe I misheard that. So right of survivorship, can we say it's not permissible in Sharia then?
So yes, if someone is actually going by right of survivorship and thinking that is according to the Sharia, then it's not, right? Because if you have shared ownership of anything with anyone, then when one of the shareholders dies, then their share is now part of the estate, and it must be distributed according to the Sharia guidelines. Now, you could, I don't know if you could again do, and I don't like this, to be honest, this whole side business of having, separate agreements or separate instructions. That probably, yes, you'll save on taxes, but it's probably going to be, opening up a lot of doors to potential missteps, right? So, somebody could technically do that perhaps, with trusting them, the other, shareholder, that they will distribute it in their good conscience, but, that's not something that I would recommend. Right.
1.5%.
Yeah. Any question on the sister side? Yeah. Yes.
Or for anybody who's non-Muslim, is there any way their non-Muslim family members or anybody who's not Muslim could inherit? Could that 1/3 bequest be used for non-Muslims or no?
Can you repeat that?
Yeah, so the question is, if somebody has non-Muslim relatives, is there any way that they could be allowed to inherit by being part of the 1/3? I'm not going to answer that question because I'm not sure, so I'm going to have to look that up. Because I do know that that is a restriction. Can they be because of part of, I don't know, so I'm not going to comment. So sorry about that. Yes, inshallah.
So just like two very close related questions. Can your beneficiaries to like death benefits or whatever, can they be minors? And also, if you have a pension, like it just goes to your spouse when you die, you can't like reassign it to anybody. How does that work with like an estate? Because not an estate, it's like a monthly payment that you don't have access to or control of.
Yeah.
Yeah. So the question is with regards to survivor benefits. So if there's a pension, for example, that has a beneficiary already listed, then that's not something that can be changed or that can be be instructed to be done differently in a will. So how do you deal with that?
So we normally don't put again pensions in the will. We don't mention it. Again, it's the out of the will contract. people sign it and then have a beneficiary directly going to that. But we can, if somebody want to add it in the will, then that's a process. We do add them in the will too.
So it can just be like an ongoing.
Yes, it can be ongoing state. Yeah, something like that. And I come back to your first question about the minor. So whatever you gave the executor will, there is two types of powers you giving to one person. One to handling your estate. The other is handling your minor kids. So for handling your minor kids, you appoint a custodian and guardian. It can be the same person. So I tell you what I do normally in my wills. So somebody come to me as a person, I make the spouse first executor and first guardian because she or he has the first right. So let's say they both die together or the spouse dies before predecease the testator. So I appoint, if they have an elder child more than 18 years old, I appoint them as a guardian for the minor. So if and then somebody have a special instruction that my home is paid out, I don't want my trustee to sell this home under the last of my child become age of 21. So trustee is bound not to sell that home until the last child become age of 21 and disperse the residue to that child.
And that stays compliant with the share? Because if you have joint ownership, like you would have to sell 50% of your house to pay out your beneficiaries.
Yes.
But if you, would that be allowed? Because if your children are small and your spouse lives in it and you die, like is she expected to sell the house and pay off the children who are under 18?
Yeah, so here's the thing. That's actually a really good question. So when we say that the shares have to be distributed, the inheritors could agree Islamically on keeping that wealth in a certain form, right, in illiquid form, for example. So they could decide that, yes, we all own this percentage of the home, but it doesn't have to be cashed out right away, right? They can decide that that's how that they're okay with it, and they'll keep that. So does that answer the question? Yeah. And also, actually, on this, so I guess I have a question too. That when you talk about the
Can you write that in the will that you actually, that asset will not cannot be cashed or something?
No, so that's not an instruction Islamically that you can give. They can decide amongst themselves.
Okay.
But Succession Law Reform Act give you this instruction. You can do it whatever you want to do it in your will.
So legally you can do it,
Okay.
but Islamically you cannot. Islamically, you cannot give the instruction to your inheritors that they must keep some part of the estate in a certain form. Because once it's distributed, it's theirs, and they can do whatever they want with it. But if they agree amongst themselves that we want... Yeah.
I understand.
Yeah.
You can write that in the will anyway.
Yeah. So with regards to survivor benefits, the pension, that wouldn't be coming out of the estate, would it? Right? Like if there's no. So that's not part of the will then, Islamically.
No, it's not.
Right? No, because it's something that is part of the pension plan, and the pension plan has defined it, and never was part of the person's wealth anyway, so it wouldn't be covered. We're talking about anything that the person owned and they've left behind. Okay, coming back to the question about the non-Muslims, so I did look up the fatwa, alhamdulillah. So yes, actually it is permissible. So the one third can be given to anyone, including a non-Muslim relative, inshallah. Okay. Somebody who hasn't asked yet, so yes, brother.
On both the Islamic and the legal aspect, how are non-liquidable assets distributed?
Which asset?
Like non-liquidable, such as furniture, property, electronics, such and such. Like how are they distributed?
So when we make a will, we said all my property.
All the property.
Yes, so it includes your real estate, includes your laptop, includes your boat, includes your cottage, everything. We make it as a one all property, and then we encourage you to make a list of that properties, whatever you have it, and then somebody have paintings, a very expensive paintings, that those or different articles or different things. So those are all become as your property.
So just curious. So if there's a property in your similar house, does that get sold off to different children? The money that's sold off to all the different children of the deceased.
So first of all, the property that's left behind, it doesn't have to be sold, right? So the distribution does not need to be done in liquid form or in cash form, right? So, for example, in a person's home, there's going to be different types of items. So as Brother Umer mentioned, Islamically as well, you can make a list, put an approximate value for each item, and that is then part of the estate, which would be distributed. And then the inheritors can decide amongst themselves that, okay, this is, my share is, $1,000. So in my $1,000, if everyone agrees, I'll take the laptop as an example, right? Because it's valued at $600, and I'll take, whatever, this coin or, clothes or whatever it is, right? So you can divide it. The inheritors can divide it amongst themselves. The key part, though, is that the distribution or anything that happens with the unanimous agreement of all the inheritors, right? And by the way, if one of the inheritors decides that I don't want my share, they're allowed to do that. Okay, they're allowed to say I don't want my share, and then their share is put back into the pool, and then it's distributed, without them. So it's distributed to everyone else according to the same distribution. So that's an important point. The second important point, which I did not mention, is that if one of the inheritors passes away, okay, so let's say somebody has, 5 children, and one of the children, one child passes away, and then and then they themselves pass away, and now their wealth is being distributed, it will not go automatically, Islamically, it will not go automatically to the grandchildren of that child who has passed away. Okay, the grandchildren would not be inheritors. So it would be distributed amongst these surviving children, and they could decide, once they receive the share, and they should, probably, they're not required to, but, they could give something to their nieces or their nephews, but they don't have a share. And this is a common misconception where, somebody's, there's kids, their parent has passed away already, and then now their grandfather or grandmother passes away, and they expect that they would have a share. They would get the share that their parent would have had, but that's not how it works Islamically.
They're not part of the 2/3, but are they automatically part of the 1/3, the last 1/3?
Not automatically. So the 1/3 is not automatic if the 1/3 was left, right? So for example, if somebody knows that their child has passed away and they have grandchildren, from that child who will not be entitled to an automatic share, they could Islamically leave up to 1/3 for them. But, it's not a requirement.
So just to make it clear, you're saying that if there's like, say for example, 3 people who are the inheritors and one of them dies, then that gets split to the other 2 inheritors? So
Yeah, like they're just not included in part of the distribution. They're not counted. And yeah.
So instead of 1/3 to each one, it becomes half to the 2 last?
So Islamically, the calculation would be done as if that child was passed away or that inheritor was passed away is not part of the equation anymore.
But if they had children,
Then it passed to their children.
included in the Sharia.
Islamically, no, that's what I'm saying. It would not pass to their children. It would not pass to the grandchildren.
Grandkids are never part of the formula.
The grandkids, if the children are there, the grandkids will not get anything, including the grandkids coming from the child who passed away.
So just to confirm, say for example, grandpa has like $1 million property, and then his son dies, so that then the grandchildren don't get anything of that 1 million.
No,
Oh, okay.
Islamically.
Islamically, they
Even
don't.
if he doesn't die, the grandkids are not getting anything directly.
Yeah, but because he has died, it doesn't automatically make them qualified to get the share that the father would have gotten.
I just add one more thing, that this is why we drafted in a way that, okay, if one of my child dies or predeceases me, so his share, if he's not married or have any issues, so his share will be distributed among other 2 siblings or 3 siblings. But if that child who predeceases me have kids issues, then his share will equally divided among the issues of that child.
So Islamically, that would not be right.
Islamic not, but succession order format.
But legally
give you
would
that
allow that.
option.
So, regarding children, minor children, in Islamic Sharia, is there a preference of who would be the custodian, who should be left as a custodian, or is that something we can decide? But there is a service, Canadian Will Registry, proxy. Is that something that should be used for storing wills?
Yeah, so Islamically, when it comes to the custody, it's not defined the way the inheritance is defined. Okay, so yes, there's guidance and there's Islamic, there's fiqh rulings around it, but it does not need to be followed in the same way that that the inheritance has to be followed. So one could choose to go by that, or really at the end of the day, what it comes down to is the best interest of the child, right? So parents are alive. We can decide who would be the best custodian, best guardian for the child, and put it, in the will in the order that we feel that we agree upon.
Can you take a question from brother?
My other question was regarding Canadian Will Registry.
Yeah.
Yes, Canadian Will Registry is an option there, but I think there's a fee there. You can pay it to them. You just make a copy or send them an original, and they store it for you. And then I always prefer people to have their wills safe and in a safekeeper. But yes, there is an option right now. It is not too much popular right now, but yeah, they are working on it. But mostly lawyers save the will if they can. Uh, the one reason is that that beneficiary goes to that lawyer and use him for a probate purposes and all that stuff because he already know the file. So that is the one reason that lawyer keeping the will. Some lawyer have 300 wills, some has 1,000 wills in their safekeeping because they know that it's a money making business at the end of the day for lawyers sometime if it's a probate thing. So they keep it, but there is no requirement the lawyer keep the will. You can keep your will, but as long as you can keep it safe, make a copy, give it to your trustee, so he knows what is the will and what is the instruction you already given.
Yeah, that's really important, right? Like, you could have a will, but if nobody knows where your will is, you've got a major problem, right? So, whoever you have as a trustee or the executor, whenever I think of death and executor, it gives me bad images of execution. So that's not what we're talking about. You're talking about executing the will, right? So yeah, just tell the executor, tell the trustee, where the will is, because you don't want to be in a situation where they don't know where anyone knows where it is.
Is there an issue with the original? Who's got the original? If the original is not found, is the copy sufficient? Like, is there issues like that?
I come back to B. I just take a question from brother. He's standing. And yeah, go ahead.
Yeah, actually, I have two questions. So the first one is about the executor. So as you said, the spouse would be like the guardian and the executor could be she or he could be the executor, or the guardianship is different from the execution. So I mean, someone would make the spouse as the first option as the executive, and a friend, then a friend. Is there a possibility to make like an agency, like a KMA, as the third option if both executors die after me or with me, for example, God forbid? Can I have an entity to be the executor of the will?
Yes, you can have as many executor or trustee or guardian you have to, but we always said that it has to be in priority. Okay. Some people said jointly, so you put two brothers as a jointly guardian for your child. So now that has to be meeting of mind between two brothers. If they are agreeing to sending him which school, he's not going to school until the court decided. So always have a priority that your spouse, your first brother, second brother, third brother, but we do not recommend to make any organization as a guardian for your child, because organization normally a court will not approve it, because every guardian, even your spouse, has to take that guardianship certificate to the court within 90 days of the death and get a certificate from that guardianship certificate. So and court will not give guardianship certificate to an organization. Yes, it has to be that way. So you need.
The second question is about this happened. I know someone did this in Alberta. I don't know if this is
okay.
Executable or acceptable in Ontario or not. They made like a standard, like not a standard, like a generic will, that this is my will and so and so, and they added schedules to the will, which is different scenarios, just in case if I pass away, if my child passes away before me, like different scenarios and different and according to Islamic Sharia, how this property will be distributed in each scenario. Can this apply or executed in Ontario?
It can if we call it codicil. So you can add an addendum or a codicil to the will, but again the thing is that the instruction has to be very clear and specific. So the will meaning that you're giving instruction. So you don't need to add any codicil. Until and until it is very important for you to add something after the will making. So if you have an executor clause and guardianship clause, but then why you need to use another codicil to confuse the judge what is happening? Do I follow the codicil or do I follow the first part which was written in the will? So the instruction has to be very clear and at the one space only in the will.
So you're saying there's no need for that, so just make it part of the will.
It has to be part of the will, yes.
It's part of the will. The schedule is part of the will, and signed as part of the will. But I mean, because according to Islamic Sharia, even there are different scenarios after my death. So like whoever survives me is like as Imam Sikander said, the inheritance will be different. If my son survives me or I survive my son, the inheritance will be different, right? And my grandchildren, are they gonna inherit from me or not? That's the scenario. So they put different scenarios, and every scenario will be applied on according to the current situation upon my death.
Yes, I was looking in somebody, I think a mosque made a will template, and they have a schedule according to Islam that if you only have a son, this is something like that. You can do it, but again, then you have a very clear instruction in your will that it has to be according to my Islamic instruction provided at the back. Whoever alive at that one, you can do it, but as long as it has to be very clear. Again and again, you have to talk to your family first. If you're giving your father or mother a share, I'm just giving example, and your child can challenge it that I am most needed for this share, so court can decide in the family favor first rather than sibling and the parents or
But
something like
this
that.
one will take much time from court, as I know, because we had the same situation in British Columbia.
Okay.
Yeah, it takes time for the court to make sure which schedule is applied.
Obviously, because the instructions are not clear, they have to involve an imam or something like that. They come in, give a witness, and that all stuff. It will prolong the process. It is doable, but maybe end up expense so much that your estate is paying basically lawyers' fees, judge, and all that stuff. So keep it simple, I would say.
So a couple of quick questions. One is about the probate and the house, and then we talked about the also sort of the beneficiaries. So I understand the beneficiaries, whatever, you've got a pension plan, you've got RSPs, the beneficiaries, that's fine. But the house, you said if it's joint, because I was under the impression that the house is joint, so if I was to pass, then they'll just go to my wife. And inshallah, my wife will, will deal with it Islamically. She doesn't have to pay probate on that, right?
No, every will has to go probate.
No, but if you don't, I mean, if the house is
But that house is do not need to go to probate if it's enjoined. Yes,
so,
yes.
So that even the joint, the idea of the joint house can bypass the
Yes,
right?
but if your wife decide not to give anything to your kids later on, then nobody can challenge that part.
Absolutely,
Yeah.
absolutely. So inshallah, you marry the righteous spouse. Inshallah, the righteous spouse will do that. So that was the second. Sorry, the second. You have said just regarding the grandkids.
Okay.
Is there a different views on it as far as the grandkids of a passing child that they actually inherit or not, or is it just that's just a side?
That's a good question. I don't know.
Okay.
Yeah.
And
Not that I'm aware of, but.
Brother Rama, are you gonna make these slides available?
I can, no problem.
His question was, is there any difference of opinion in fiqh with regards to the inheritance of grandchildren for a child when their parent has passed? Have you heard something differently?
No, I haven't. But I
Okay.
actually, because I
did one Azhar. It's not directed to me, but I was told that it was came from the Azhar.
Okay.
So you asked me because I actually talked to brother Ibrahim Dani. He does Islamic will.
Yeah.
I've had a discussion with him many years ago because I was dealing with him regarding my father-in-law, and we talked about the grandkids. So it was brought up that I had the impression from him that it may be possible some different jurisprudence that will that says that the grandchildren of a past child may inherit. But the only
Allahu
problem is if you do that, then you leave the door open for challenges from other grandkids whose parents didn't pass.
Yes.
So that was the only
Yeah.
concern.
Yeah. Okay.
Yeah,
No,
the
it's good to know.
major, I think, the issue we have is that Islamic law is very straightforward. It already defined. The shares are there. But obviously, as a human being, we have our own preferences to some time. Will of Allah is greater than anything else. But as a human being, we are weak. We sometimes think about differently to pass on the assets of our minor children or something like that. So that's why we are trying our best to reconcile the Canadian system and Islamic system somehow. It's still working on it. It's a very new concept in Canada right now. It is many Islamic wills are making. I doubt that there are many Islamic will are not basically Islamic. So if you take one ingredient from one part and second ingredient from second, it's not. Basically, it's a mixture of both. It's not. So Islamic will has to be Islamically done. Whatever your wishes, it doesn't matter. It's the Allah's will. But if you take one ingredient from Islamic will and then other ingredient for Succession Law Reform Act, it is not an Islamic will. Just to let you know that it is not 100% Islamic will. Yes, it is, but it is not 100% Islamic will. Yeah, he asked me first time. Go ahead.
Yeah, I have a quick question there. Usually, your the money that you left division and and the real estate division according to Sharia, because it will become complicated because for the house, for example, 50% is already going to the wife, and then what will happen to the rest? Like, how will you? Because I don't know exactly how much is the portion for the spouse, but I think it's 1/5.
1/8.
Yeah.
Yes.
So if it is 1/8, she already owes money to the kids.
Yes, it is. One thing you can do if there's a situation like that, I was no, no, no. I was having a CPD, and then they're talking about this thing. I think you can mention in a will that I am having this property with my spouse as joint tenant, and then this is my instruction that that property will be divided according to my will, my share of 50%, something like that, and then spouse has to say yes or some kind of contract of it is, but it is again complicated. It has its own complications. Spouse can say that it is not my signature, I never agreed to that, this is not a right contract or something like that. So that is, but it is a possibility but not a recommended.
How do you solve this conflict of interest? I see it's kind of conflict of interest. I'm sorry, but typically you have to trust someone. I'm fine for wife, but you trust someone after you pass away. In case of they didn't follow your instructions, I expect the one who passed away will be in trouble because he didn't follow a clear instructions from beginning that everyone takes according to Sharia. And this one I tried to make a kind of research, but the point that can we, as a Muslim, it's not about trust, it's about should we make the trust in anyone, in something you are going to be asked from Allah that you didn't make the right thing. It's hard to answer this question, especially in kind of Western country, which I mean in case of you made 50-30% and you are the one who paid the money for the house. On same time that after you passed away, you need to take care or at least try to make your family safe for some time until they made their life, maybe sell the house or decorate the house, and so it's a very hard decision. Maybe I will ask the imam in one-to-one, but it's a really hard decision for this one.
So I'm just going to go for a moment. No, thank you for that. I'm just going to go back to that question about the the grandchildren inheriting. So there may be a little bit of nuance, and that is there's two scenarios, right? So one is that a person has children, and his children have children, right? So he has his own sons and daughters, or her own sons and daughters, and then grandchildren as well. Now, from their own son and daughters, one of the child has passed away before the parent passes away. Okay, so they're alive, but their child is no longer alive, and the grandchildren are alive. In that case, my understanding is, and I was trying to just read up different fatwa, I don't see anywhere where the grandchildren would receive a share. Allahu alam, I could be wrong. However, the second scenario is that the parent passes away. Okay, the individual in question passes away. All of their children are still alive. Before the distribution happens, okay, before the inheritance is distributed, one of the child passes away. Okay, so now the passing away of the child has happened after the individual passed away, not before. In that case, yes, the grandchildren will receive the share that they were supposed to receive. Okay, so we go by whatever the situation was at the time of the passing of the individual. Okay, at the moment when the inheritance rules kick in, that is how the distribution happens. Even if one of the inheritors are no longer there, then their inheritors will take that share. Okay, so just to clarify that, inshallah. Question from the sisters, yes. So I'm going to answer from I don't believe so. So this is a clause that.
Yes, I don't see that clause in any Muslim will. I think that in this, the question is that the inheritance clause, if your child inherits something directly from you, will it become their family net property? So we stop it here, but I think Islamically it may not be allowed in that way, because I don't see it anything in any Islamic will who do that. I can do some research, but yes, in Succession Law Reform Act, we are allowed to do it, and we are doing it. And we also add one more clause that people like. This is why when as a lawyer, we talk to people, we listen to them, what exactly they want to do. It's a couple of meetings, and then we get end of the idea. So one of the client want to see that if my child has any child who is born outside the marriage wedlock, the Islamic marriage wedlock, I don't want that child to get anything from my will. So I drafted a special clause for that client that if a child of this child is born outside legally married or Islamic married, it will not inherit anything. So that's with outward. So this is something that you talk about it in your will and provide the wishes.
So yeah, so going back to that point, Islamically, it would not be permissible to limit that more than what is, it would be permissible to limit it only if it is more than what they would receive under the Sharia, right? So I'll give you an example. So, he gave the example of, December 1st, a person is alive, they pass away December 2nd, and, their child gets the inheritance, and then, something happens, right? So there's a divorce or that individual passes away. So Islamically, right, you cannot give that directive and say that my wealth, which is going to be passed on to my child, cannot be inherited by anyone else, as an example, okay? So, that's not a restriction that you could put Islamically. Because once the wealth has transferred and has become the ownership of the child, then if they were to pass away, it would be distributed according to Islamic rules. Now, let me ask you a question. Based on that clause, would it restrict it in the case of death as well, or only in cases of divorce?
In case of death as well.
In case of death as well.
Stop it there. If,
Okay.
let's say, the bank gives $500,000 in their bank account inheritance, then that's just his or her money.
Yeah.
Until and unless she specifically in writing says that I'm going to join it or I'm going to share it with my husband or wife. Otherwise, husband and wife has no right, even died or even. No. That's why it stops here.
Because of that clause, right?
Of that clause.
But Islamically, you cannot restrict it, right? You cannot say that, I don't want this inheritance. I want this inheritance to stop at my child and not be then distributed if they were to die or something were to happen, right? Yes.
I understood it. I don't know, like Islamically, husband and wife, their property should be separate. That's what I'm understanding. Now, maybe I didn't understand the example. I don't know. The example looks to me, as I understood it, that still it is Islamic.
So what the clause he's talking about restricts what happens to the money from my estate after it goes to my child. So it's restricting it, right? So it's saying that it cannot be inherited by my child's spouse. So it will stop at my child.
Okay, my understanding, and you maybe can correct it, okay, that you're putting a clause that actually that inheritance wouldn't go to the common property of a husband and wife.
No, it's not only that. So what he just confirmed, that it will stop it even in the case of an inheritance. So yes, in the case of divorce, I understand, right? You could say, and in the case of.
Not the case of divorce, it's just common going as a common property. Okay.
It will not become a common property automatically. So let's say
Yeah,
that,
that's what I-
let's say my son inherit a home altogether. It's paid off everything, and then I said, okay, my only son inherit that home. It will not become a property of both of them. So that home always stays on my son's name for his own purposes. Will not become a.
Islamically, that's fine. That's not a problem Islamically. The problem Islamically is is that the son's wife now will not be able to inherit.
No. Until my son specifically gave that property or shared that property with her, until then it's not.
He will have an Islamic will himself, and then that is actually he's going to be.
That's what he want to do. He can do whatever he want to do. I just try to protect him. That's all.
So which one? So that's a good scenario. So which one would be in effect then? Would it be, your wish that you want the property to stay only with your son and not to be, passed on, or would it be his Islamic will that says that his wife is entitled to the share in the
Yeah.
property?
So my job is done when I give my wishes and give it to my son. Now, if he make a will and saying that my property will be given to my wife, that's his wish. He can do whatever with his property. So I done my part. So I give it to him, only to him. Now the next day, he can share it to the wife. No problem for him. So my instruction or my wishes is only up to that point that it only goes to my son.
Right.
Now my son is capable of do whatever he want to do.
If he does not have an Islamic will, then what happens?
So it automatically transfer it. But the thing is that if that property he's mentioning that in his will, then obviously he's confirming that he wanna share that property with the spouse. Otherwise,
What I'm saying is if he doesn't have a will,
okay.
yeah, then what?
Then this clause will protect that part.
Okay, I think this is really getting complicated and probably unlikely. So let's just leave that for afterwards, inshallah. It's gonna go on forever.
Yes.
It's protecting, like, for example, like
That's fine.
I give my daughter $1 million for my inheritance. It protects her from, let's say, God forbid, she gets divorced the next day, and all of a sudden, that her husband will think.
I understand that.
That's the part we're protecting.
But then if they have a good marriage, and then she's going to put that in her inheritance.
That's up to
the
her.
husband will inherit, a quarter, his quarter. And
But what my only point is that Islamically, it has to be part of her inheritance. She doesn't have the choice of saying that I don't want this to be part of the inheritance. But anyway, there's Dr. B, your hand was. Yes.
Comment and two quick questions. The comment is some of the options are really tax heavy. So when you plan your will, when you plan your affairs, think of income tax.
Exactly.
Because the tax
Income tax.
Income tax.
Think of income tax, yeah, when you're planning.
So
Yeah.
this is the
Yeah.
comment. The question is just to confirm that the probate does not apply to the family dwelling, but would apply to any other residential property I own with my wife.
Yeah. The exception I think is only for the matrimonial home. If you have a matrimonial home, that is the exception only. Otherwise, rest everything goes within the assets.
Thank you. And Chef, I have a question for you. There are something that has no value during my life, but my death will trigger a value. Life insurance, pension plan, survivor benefits. If I designate a beneficiary to those, do I have to calculate them into my inheritance? Or because they had no value in my will, I can distribute at my will?
So I'm not 100% sure on that, so I'm going to be careful. My initial thought would be that it would not be calculated because it is something that's defined and that's not owned by that individual, right, until they die, right? So it's a promise for something to come after their death, but it's not anything that they own, and since they don't own it, it would not be part of the inheritance. Potentially, though, it could be included, but I'm not going to say that because I can see both ways.
The flip question is, there is tax implications of my death.
Yeah.
Then do I factor in the tax when I distribute because different assets will have different
No.
tax implications?
No. So when you distribute, it will be according to the Sharia rules, and whatever is owed by whoever when they receive it, will be theirs. Of course, you can plan it if you want, but at the end of the day, that's not something that you're going to consider from the Islamic point of view. Yeah. Allahu
But
a'lam.
we highly recommend that before making a will, you need to see an accountant too, because as you said that there's income tax, there's other things, so he can manage or he can make a plan for you in a way that you save some money out.
The government makes a lot of money from people dying. Yes.
Circling back to the point, just based on the last question, would you Islamically recommend or not recommend having that clause in a will?
Islamically, would I recommend having that clause or not? What is it? What do you call that clause?
We call it family law clause, but
I don't know. I don't have an opinion on that right now. I don't know about it enough to say whether it's something I would recommend or not. I think it really depends on family circumstances and relations and how committed people are to Islamic laws.
Can I do a quick follow-up question?
Yeah.
When it came to the two witnesses,
Yes.
the minimum of two. If you have more than two, do all the witnesses have to be there, or if two of them are there, that's like sufficient? What about more than two?
I never see anybody who having more than two. I think the requirement is straightforward. They said two witness. They do said in the law that cannot be less than two, but I don't see that there is more than two witnesses.
The witnessing of a will is not like a nikah, right? That you're gonna have 50 people attending, right? But I get your point, right? So I would think that more than two are probably allowed.
I don't think so. I think two is the law basically. I never see it more than two anywhere.
No, but if somebody has four, the judge is not gonna throw it out.
I can go back and check that one point, but I don't.
So that goes back to the affidavit. Is it difficult to get that? Because you said notarized notes are useless. What's required to get an affidavit then?
So what's required to get an affidavit? If
Yes,
notarized notes are
affidavit of
useless?
subscription of will is a simple affidavit. We prepare it that I so and so was present in presence of the executor and in presence of another witness, and I saw that we all signed together in each other's presence, and you need to get this affidavit commissioned by an oath commissioner, and then that's it. And then you add this affidavit at the back of the will or the front of the will, it become part of the will.
So just a quick a note here. I think a lot of us who are not lawyers confuse, notarize with getting it.
Notarization has no
Versus
value.
what you just said right now? An oath commissioner.
Oath commissioner.
Right. What do you call that when you have it signed by an oath commissioner?
Affidavit.
An affidavit. Okay, so that essentially is, I think, what a lot of us call notarize, right? Is to have a commissioner of oath sign off on a document, right? Which, in other words, for us who are not lawyers, we call it notarize,
Yes,
right? I know, but it's not notarizing. I know.
Normally, the lawyers do not sign anybody else's affidavit because there are potentially a legal issue. One of the lawyer being sued a couple of years back. He just signed the affidavit,
Okay.
and then that will got challenged. So the beneficiary claimed that this lawyer did not give our father or mother proper legal advice. The lawyer said, I just execute the affidavit. I don't know anything about this. But he got granted for 2 years. So we, as a lawyer, we do not sign these
But
affidavits
there's other
until and
people-
unless we do it. Yes.
But there's other people who are commissioners of oaths who can do it. Yeah.
Okay, General, my question that I've been cut off 3 times.
Yes,
Can I
right.
ask a question and leave?
Absolutely.
It's for Brother Umar. In Islamic Sharia, under special circumstances, your brother and sister, they become inheritor even if you have a wife and kids. So if I have a property and I have a brother and sister living abroad, how can I assure they're going to get their share in that property and they're not Canadian?
If the properties are abroad, you have to make a will in that jurisdiction.
No, the property's here, right?
The
Property's here in
Okay.
Ontario, but the inheritors are not all here.
But in Islamic Sharia, sometimes they become inheritor under special circumstances.
Yeah.
So how can we assure that they're going to get their share of the property even they're not Canadian?
That's the executor job. If it's a will, an executor is basically the person who execute according to your wishes in the will. So he open the will, he see that, okay, you want to put this part to your brother, and if no beneficiary have any challenge of it, then he can just give this check to their country, he can give money, cash, whatever it is. Yes, he can distribute it. It's all the time people doing that. That's totally fine. If there is a mortgage on the property and it's executor will not pay anything from his pocket. So if it's a property is fair and clear, he can sell it. If it's a mortgage, he still sell it, pay out the mortgage, whatever the remains left, he execute it according to your will. That is why whenever you're writing a will, you need to know your assets. Do not commit anything more than what you basically own in the will.
Executor have kind of how to make sure it is going to back to court, for example. So one of the father or mother outside the country, and they send them some check. How the any kind of governance on the executor, or it's just executing the will and that's it.
So the executor get a certificate of appointment, and then he hires a lawyer for all this stuff. Everything goes into lawyer trust account, and then lawyer distribute the assets from his trust account. So if the will says 5,000 to my brother in Lebanon, let's say, so he asks the address of the brother, bank account of the brother, and then send wire money to the brother according to the will. This is how we normally do it.
Can they become owners of a property if they're not in the country?
No.
No.
Ontario just legalized a law that non-Canadian cannot own a property in Canada until they have to pay NRST. This is a expensive.
Okay, we're wrapping up, so we'll take the last question, inshallah, and then if anyone else has questions, you can ask privately. Yes, go ahead.
Do you have to keep updating the will every time you have more children, more grandchildren, or something?
Not the more grandchildren. Yes, if you have a child in the family, you have to update the will. If you marry, remarry, or divorce, yes, you have to do that will.
So you can't use just like general language in the will, like instead of listing the names of kids, can you say my biological children get split? So you
I normally just write all the people name, whatever you want to, just to make things easy, because you can add an addendum, you can change the will, just one para of the will, but it is always better if you name your heirs in it, that this is my heirs, basically. Yes, it has to be. It has to be very clear who's your family is.
Biological is a big risk.
I know.
You don't know somebody will come at the end. Can be Zagoria and also at Canada.
Okay, so let's just finish this question, please. Sorry. Yeah.
Regarding your clause, I think most people's objective of putting that in is to protect the asset that you're transferring from the spouse of your child, right? Like
Sorry?
for divorces.
Okay.
The clause that you mentioned. I think most people's objective of putting that in is to safeguard from the spouse of the child.
Yeah.
But if the child dies with you or soon after, or they don't have a will, is that money just gone because you put in that clause and their kids can't get it? Or can you customize the clause to say my child and his?
If we get instruction, and yes, we can customize the clause. Yeah. Thank you, everybody.
Okay, Jazakallah khair. Thank you so much, everyone. I know there's tons of questions. Brother Omar's still here, I think. So, like, he's not. Are you running away?
No.
Oh, he's here. Okay, so if you have questions, you can ask privately, inshallah. Thank you so much, Jazakallah khair, and those who are online as well. We end. Subhanakallahumma wa bihamdik. Nashhadu an la ilaha illa ant. Nastaghfiruka wa natubu ilayk. Assalamu alaikum.